Well, hi everyone. I'm Hana Kern. I'm going to be talking to you today about Washington law and what's new in Washington law, the changes that we've had over the past year. A little bit of an overview. We're going to spend some time on the new Long-Term Care Trust Act. We're going to talk about the Health Emergency Labor Standards Act, and then we're going to talk about updates to some existing laws. So starting with the Long-Term Care Trust Act, what is it? Well, starting this coming January 1 of 2022, there will be a new payroll tax in effect in Washington. The purpose of that is to fund the Washington State Long-Term Care Trust. It creates a long-term care insurance benefit for certain qualified individuals. So the first question we get always is, how much is this going to cost me? Your employees will want to know that. The tax is 58 cents per $100 of wages. And this will require you, the employer, to withhold that is to collect it through payroll deductions. What does 58 cents per $100 translate to? Well, an employee making $75,000 a year would pay $435 per year. So the next question, of course, is what do I get? What benefits does this provide? Employees that pay into the fund will be eligible to access up to $100 a day to a maximum of $36,500 to pay for long-term care assistance. They can access these funds starting in 2025, and that $36,500 will be adjusted for inflation over time. What can your employees use this benefit for? The fund can be used to pay for expenses associated with needing assistance with what are called activities of daily living, or ADLs. These are generally tasks that are essential and routine to many of us. Most healthy individuals can perform them without assistance, but some folks do need help with them. It's things like eating, dressing, toileting, self-care, speaking, managing medication, those kinds of issues. So now, who can receive this benefit? The person has to be qualified. Number one, they have to live in the state of Washington at the time they need to use the benefit. They have to be unable to do 3 activities of daily living, and they have to have worked and paid into the fund for 10 years or for 3 out of the last 6 years. So one of those 2 requirements, either for 10 years or for 3 out of the last 6 they've been paying in. And in addition to that, they have to have worked at least 500 hours each year. Finally, they have to be at least 18 years of age. Now, one of the things that we've been hearing a lot about is an exemption option. You may have heard about this. There are a lot of questions around this. There is a one-time option for employees to exempt out. That is, they don't have to pay that 58 cents per $100 tax if they have other long-term care insurance. That other long-term care insurance is equal to or better than the state plan which is offered. And they have to have that alternative plan in place by November 1st, 2021. So that's just over a month away. So that deadline is coming up. There's more information about this particular opt-out option, and you see the link on my slide there. People have questions about that. So lots of questions have arisen. I'm going to try to answer a few of them that we have gotten frequently. The biggest complaint that I've been hearing is, wait a minute, I'm going to need to pay into this, but I'm never going to see the benefits. People who are close to retirement, for example, someone that's going to retire in a couple of years is never going to see a benefit from this insurance, but there is no opt-out option for people who are close to retirement. So we've heard complaints about that. Another big complaint about folks who will be required to pay in but will never see the benefit is people that live outside the state of Washington but work in Washington. Recall that the benefit is only available to residents in the state of Washington. So if you live in Idaho or you live in Oregon but you work in Washington, you are still going to have this tax withheld from your pay, but you will never see the benefit. So people aren't happy about that. Another question that we're getting is, wait a minute, a private plan? Should I put a private plan into place? Is a private plan going to be better for me? Will it be less expensive? Will it provide me with better options? The answer to that question is maybe. The particular plan through the state is not portable, right? You have to live in Washington to take advantage. Many private plans are portable. The Washington state plan you have to be unable to do 3 activities of daily living to obtain benefits. Some private plans only require that you be unable to do 2. So what kind of private plan qualifies for an opt-out? Again, not particularly clear. The rule is that it has to be a qualifying plan, and a qualifying plan is defined as one that is equal to or better than the state plan. Well, that's not really clear what that means. Plans have different features. Maybe the plan that you have privately is better in some respects, but worse in others. So a lot of unanswered questions there. So the other concern that we're seeing too is folks who sell long-term care insurance in our state are now swamped. It's probably not possible to put a private plan in place at this late date. The response that I've heard from Employment Security about that issue is that the intent of that opt-out was not to have people up and running to suddenly get insurance before the deadline. The goal was, if folks have been paying in and have this established insurance, then there's a carve out, there's a one-time exemption. There will not be exemptions in the future. That's another question we've been getting. But what we've heard on that is that this is truly a one-time exemption, and folks coming into the workforce later on, either because they are young adults coming into the workforce or moving into our state, they will not have the option to opt out. They will have to pay into this fund. One other concern that folks are having is, will this benefit cover my long-term needs? Unlikely. $100 a day these days really doesn't go very far toward covering long-term needs. A $36,500 maximum won't either. Many of you may know that memory care can cost up to or more than $10,000 per month. So it really depends on what a person's needs are as to whether or not the state plan will cover it. So that's the information we have on that particular law. We are continuing to watch rulemaking, watch what's happening with it, and we'll hopefully be able to clarify and explain anything when new rulemaking comes down. The next law I want to discuss with you today is Helsa, the Health Emergency Labor Standards Act. This act became effective on May 11th of this year, 2021. It's essentially a codification of portions of the emergency proclamations that were issued by Governor Inslee over the last year and a half during the pandemic. Helsa establishes certain requirements in the event that a disease like COVID-19 is declared a public emergency in the future. And I'll go over some of the requirements here. First of all, frontline workers are entitled to workers' comp, wage replacement, and medical benefits. And importantly, this law creates a rebuttable presumption that if they were exposed to the disease, that exposure occurred on the job. That was a concern that we were seeing with workers' comp, that most folks, if they were exposed to COVID, it's hard to prove that that happened on the job and that it was covered by workers' comp. We really are sweeping an infectious disease like COVID into the workers' comp paradigm with this law. What is a frontline worker? It is broadly defined for this law. So it is not only what we think of as frontline workers, although of course those folks are included, folks like law enforcement, firefighters, paramedics, but we are also including employees working in food processing, janitorial and food service workers, childcare workers, retail employees. There's a list on your screen that you can see. A lot of other folks, restaurant, hospitality industry employees, home care aides, nursing home employees, and our slides will be available to you, so you don't need to frantically take notes here. Let me cover a few of the other requirements of Helsa. First of all, there is a notification requirement, a couple notification requirements. One, employers with more than 50 employees at a workplace have to notify L&I within 24 hours if they've had 10 or more employees test positive for the infectious or contagious disease. And they must notify their employees if there's a potential exposure to the disease. Employers are prohibited from discharging, replacing, or discriminating against high-risk employees that either seek accommodation or they seek a leave because they need to be protected against the infectious disease. So, and employers will have to follow that same interactive process that you do when there's other accommodation situations. The law also provides that if no accommodation exists, The employer will have to provide the employee with all available leave options. So these protections, if this sounds familiar, it's because a lot of these protections have existed during COVID-19 under Executive Order 2046. So Helsa has now made them, Helsa has turned them into the law. Let's go over a few updates to existing laws. I'd like to start by talking about Washington's non-compete law. One important thing to remember about our state's non-compete law is that that is the earnings floor. So only employees or independent contractors who earn more than a certain minimum threshold can be held to non-compete agreements. So if the employee has earnings less than that threshold, the non-compete agreement is either void or it's considered void and unenforceable. That floor was $100,000 for employees and $250,000 for independent contractors, but those numbers went up on January 1st of 2021. So for this year, for employees, that threshold floor of how much they have to make in order to have a non-compete be effective is $101,390. And for independent contractors for this year, it's $253,475,000. And keep in mind that these numbers will continue to be adjusted for inflation. So we recommend that if you have non-competes that reference that floor, it's better to reference that as tied to what the state requirement is, as opposed to putting in a fixed flat number. We've had a change to the threshold for classifying employees as exempt under Washington law. So effective this coming January 1 of 2022, the threshold salary level for an employee to qualify as exempt will increase to 1.5 times current state minimum wage for small employers, and those are employers with 1 to 50 employees, and to 1.75 times the current minimum wage for large employers, that is 51 or more employees. So the dollar change is estimated to go from $821.40 per week to $975 per week for the small employers, and from $958.30 per week to $975 per week for the large employers. So keep in mind that this is the minimum under Washington state law. This is actually greater than the federal threshold, and employers have to meet both. So whichever of those is higher, you have to meet. In this case, that's Washington requirements, so you have to meet those. And just want to remind you that that is, of course, not the only requirement for qualifying employees as exempt. There are other requirements, such as job duty requirements, and there has been a change actually to the Washington state duties tests. These were revised in 2021. They were made more consistent with federal law. So you want to make sure that you are aware of those. Of course, we are happy to answer your questions if you have them. And one more note on that issue, there were also some changes made to the computer professionals exemptions in our state. All right, let's turn to PFMLA, Paid Family and Medical Leave Act. The big change this year in 2021 occurred effective July 25th, and that is that the list of individuals for which an individual can take leave has expanded. The definition of family member has changed. So previously, a family member was a child, grandchild, grandparent, parent, sibling, or spouse. Now, there are additional folks who fall into family members. In addition to those things I just listed, it also includes an individual who regularly resides in the employee's home, or where that relationship between the employee and that other individual creates an expectation that the employee will care for that person and the individual depends on them for their care. So that encompasses situations where someone might be living in your home that you care for as an employee. It does carve out an exception for a straight roommate situation. It does not include an individual who simply resides in the same home as the employee, but with no expectation that the employee care for them. So, this PFMLA is not going to apply if you've got a couple of college roommates living with the employee and one of them gets sick. That is not intended to be covered by this new expanded definition. The other PFMLA change that I want to draw to your attention is the temporary pandemic leave assistance grants. This is a temporary amendment to the law, It's only effective through June 30th of 2023, so not next June, but the following June. And it's a new program. It arose because of the high unemployment rates due to the pandemic. Lots of folks were unable to work the required number of hours to obtain unemployment. So this provision basically modifies the way in which hours are counted and allows these grants for paid leave for the workers who are unable to satisfy the hours worked threshold to qualify for unemployment benefits. All right, I finally want to touch on one more new law. This is actually an emergency rule from our State Department of Labor and Industries, and it requires Washington workers to be protected from wildfire smoke by their employers. So it only applies to certain employers. Those employers have to train employees and supervisors about wildfire smoke and the dangers of that. They have to verify that employees showing any symptoms of smoke exposure are receiving appropriate care, and they have to take action to remove or reduce exposure. So this isn't going to apply to everyone, so we just want to touch on this, make sure you folks are aware. The rules do not apply to all workplaces, basically indoor workplaces where the doors and windows are kept closed. That's a paraphrasing, but generally, if you're in an indoor workspace, doors and windows are closed, you don't have to be concerned about this, but other folks do. So there is a brief grace period for enforcement of those rules. Initially, Washington is going to be focused on compliance rather than punitive enforcement, but you do want to be aware of these. And it's interesting to note that Washington is the second state behind California to adopt wildfire smoke regulations protecting workers. All right, folks, that is all I have for you today on Washington law updates. I sure appreciate you listening in. On the final slide there, you'll see my contact information. I would love to hear from you if you have any questions for me.